There is a document in the National Archives that most Americans will never see. It sits in Record Group 49, filed under the Bureau of Land Management. The date on the cover page is June 1, 1909. The title reads Restoration of Lost or Obliterated Corners. It is a circular issued by the General Land Office in Washington. The opening line should alarm anyone who owns rural land in this country. It references an increasing number of letters from county surveyors across the nation reporting that original boundary markers had been destroyed, not gradually weathered, not misplaced during construction, destroyed. The stone monuments and bearing trees that had defined property lines for over a century were gone. And the government's response was not to investigate who removed them. It was to authorize new surveys to replace them. To understand why that matters, you have to understand the system it replaced. Since 1785, the Public Land Survey System had defined property boundaries across every state west of the Appalachians. Independent surveyors general in each state hired local deputy surveyors, men from your county, your region. They physically walked the land. They set stone cairns at section corners. They blazed bearing trees and carved township markers into bark. They recorded every detail in field notes. The soil, the slope, the nearest creek, the species of every marked tree. Those field notes became part of the land patent itself. In 1888, the Supreme Court ruled in Cragen v. Powell that survey plats and field notes were legally inseparable from the deed. Your property was defined by what a local man found on the ground, not by what a bureaucrat decided in Washington. That distinction mattered. The original system was local, physical, and accountable. The surveyor who set your corners lived in your community. He answered to a surveyor general appointed for your state, not to a commissioner in Washington. The evidence of his work was carved into living trees and stacked in stone piles you could walk out and touch. If your neighbor disputed the line, you could both stand at the monument, see the blazed oak, read the inscription. It was a system built on a radical idea, that the ground tells the truth and the ground belongs to the people who stand on it. Destroying a survey monument was a federal offense even then. Congress understood that the physical evidence of your boundary was the last line of defense between your family and anyone, government or corporation, who wanted your land. And that system had worked, imperfectly but recognizably, for 125 years. Now, to be fair, the old system had real problems. Surveys conducted with 19th-century instruments were sometimes inaccurate. Wooden stakes rotted in wet soil. Bearing trees were cut down by settlers clearing farmland. Some corners genuinely disappeared through natural erosion over decades. The government had legitimate reasons to establish procedures for restoring obliterated boundaries. Every bit of that is true. But what happened between 1909 and 1910 was not a reasonable adjustment. It was a demolition, and the timing tells a story the official explanation cannot absorb. 4 pieces of federal legislation passed between March 1909 and June 1910, 15 months. The Resurvey Act of March 3, 1909, authorized the Secretary of the Interior to order resurveys of public lands wherever he judged the old surveys obliterated. It gave one man the discretion to declare your boundary markers invalid. 3 months later, the General Land Office issued the circular about destroyed corners. On June 25, 1910, the Pickett Act gave the President authority to withdraw any public land from private settlement with a single executive order. No congressional vote, no public comment period, just a signature. A separate 1910 amendment expanded resurvey powers even further. And the 1910 Appropriations Bill replaced the entire system of independent state surveyors general with a centralized field surveying service answering directly to the commissioner in Washington. For laws, each one removed a different layer of protection for individual landholders. Each one concentrated power in fewer hands, all within the same 15-month window. If this were the only evidence, it could be dismissed as bureaucratic modernization. But it is not the only evidence. Not even close. Go back 2 decades. From roughly 1875 to 1898, an organized crime syndicate operated across the American West. It was led by a former schoolteacher and county surveyor named John A. Benson. The Benson Syndicate obtained contracts from the General Land Office to perform official cadastral surveys. the surveys that created property lines. Then they fabricated the results. Not partially, not carelessly, fabricated. They filed fictitious field notes describing land they never walked. They drew plat maps of terrain they never measured. They invented bearing trees that did not exist and recorded coordinates for monuments they never set. Government examiners later found that some surveys were conducted during deep winter, when snow made fieldwork impossible. Surveyors claimed to have covered more than 6 miles per day through mountain terrain in December. They described trees that did not grow in the areas they claimed to have surveyed. One plat of a township near what is now Yosemite National Park showed the Merced River more than 2 miles from its actual position. The topography bore no resemblance to reality. In California alone, government estimates indicate that nearly 1,000 townships were affected. Approximately 20 million acres, roughly 20% of all the land in the state. The syndicate operated in at least 10 states and territories: California, Nevada, Oregon, Colorado, Arizona, New Mexico, Idaho, Montana, Utah, and Washington. This was not a rogue operation in the shadows. 2 successive California surveyors general were part of the ring, the very officials responsible for approving survey results. They signed off on payment requests running 200 to 700% above original cost estimates. They approved contracts that independent government examiners had already rejected as fraudulent. They did this for years under the official seal of the state. In 1887, a federal grand jury in San Francisco returned 41 indictments for perjury and conspiracy. When the cases finally went to trial in 1892, every single defendant was acquitted on legal technicalities. No one served a day. Consider what that meant for the families who settled that land. Families in California, Nevada, Oregon, who worked the soil for years and built their lives around property descriptions that trace back to Benson's phantom surveys. They believed their corners were real. They believed the plats were accurate. They had no reason to doubt them. And none of those fake surveys were ever fully corrected. So when the 1909 Resurvey Act authorized the Secretary of the Interior to replace obliterated corners, which corners were being replaced? The legitimate ones farming families relied on, or the fraudulent ones Benson's men had invented from whole cloth? The law did not distinguish, could not. The records that might have clarified which surveys were real and which were fiction were tangled beyond recovery, or, as we will see, eventually destroyed. That is the question that kept me from writing this script for over a week. The dates are confirmed, the statutes verified, but the implication of connecting them felt reckless. For laws centralizing land survey authority pass in 15 months. The largest survey fraud in American history goes effectively unpunished just a decade earlier. The system those fraudulent surveys corrupted is then replaced by federal engineers answering directly to Washington. Each fact stands on its own. Together, they suggest something that cannot be proven but also cannot be dismissed. That the restructuring was not about fixing the system. It was about controlling who draws the lines. And then I found Richard Ballinger, and the doubt became much harder to maintain. Richard Ballinger was a former mayor of Seattle who served as commissioner of the General Land Office before entering private law practice. One of his private clients was Clarence Cunningham, who had filed 33 coal land claims in Alaska while quietly representing the interests of the Morgan Guggenheim Syndicate, J.P. Morgan, and the Guggenheim family, 2 of the most powerful financial entities on the planet. When William Howard Taft became president in 1909, he appointed Ballinger as Secretary of the Interior. The fox, quite literally, guarding the henhouse. Ballinger's former client's land claims now fell under the jurisdiction of Ballinger's own department. Within weeks of taking office, he restored 3 million acres to private use and fast-tracked the Cunningham coal claims. A government investigator named Louis Glavis compiled a 50-page report documenting the corruption. Ballinger removed him from the case and ultimately had him fired. When the chief forester of the United States, Gifford Pinchot, publicly supported Glavis and called for a congressional investigation, Taft fired Pinchot as well. In January 1910, the same month Congress was expanding federal power over land surveys. Collier's magazine ran the story under a headline that still resonates: "The Whitewashing of Ballinger. Are the Guggenheims in charge of the Department of the Interior?" A congressional investigation unfolded from January to May 1910. Ballinger was exonerated on a 7-5 party line vote. He resigned within a year anyway. His successor immediately rejected the Cunningham claims that Ballinger had been advancing. The lawyer who dismantled Ballinger's defense during those hearings was Louis Brandeis, who would later sit on the Supreme Court. The scandal was so explosive that it split the Republican Party in half. Theodore Roosevelt, disgusted with Taft's handling of the affair, ran against him as a third-party candidate in 1912. The resulting vote split handed the presidency to Woodrow Wilson. A fight over who controlled American land reshaped the entire political landscape of the country. This matters because Ballinger was not a peripheral figure. He was Secretary of the Interior. The Resurvey Act, the Pickett Act, the restructuring of the survey system, all of it fell under his department. He had final authority over which corners were deemed obliterated, which surveys would be redone, which lands would be withdrawn from settlement. And during the exact months these laws were passing, he was documented, through congressional testimony and front-page national reporting in 1910, as using his office to transfer public land to corporate interests. That is not speculation. It is part of the historical record. But there is one more piece, and it is the one that unsettles everything. In 1926, the General Land Office, acting pursuant to House Report 358 of the 69th Congress, destroyed every docketed homestead contest case file from 1883 to 1908. The official justification was 4 words: useless papers. These were the records of disputes between homesteaders and the federal government over land claims, thousands of cases documenting which families challenged their boundaries, which surveys were contested, which entries were flagged for fraud, which lands changed hands under pressure. They covered the exact decades when the Benson Syndicate was fabricating surveys across 10 states. The same decades when the Oregon land fraud scandal saw nearly 100 people indicted, including a sitting U.S. senator and a congressman. The same decades when land speculators were bribing General Land Office officials to approve fraudulent homestead entries. Every file from 25 years of contested land ownership in the American West was classified as useless and incinerated. The government burned the paper trail. Hold 2 facts in your mind at once. Between 1850 and 1871, Congress granted approximately 129 million acres to railroad companies. States added another 51 million. Every acre had to be surveyed and titled before it could be sold or developed. The survey system was the gateway to converting public land into corporate assets. By 1910, the people who controlled that system had been caught repeatedly using it to transfer land to private syndicates: the Benson fraud, the Oregon land fraud, the Ballinger-Pinchot scandal. Each time, the pattern repeated itself. Prosecutions that failed on technicalities, investigations suppressed, whistleblowers fired. And then, quietly, the system was restructured in ways that made independent oversight more difficult. What if the 1909 Resurvey Act was not about restoring accuracy? What if the Pickett Act was not about protecting public lands? What if replacing independent state surveyors with federal engineers was not about efficiency? What if each law served a simpler purpose, removing the people who could say no, the local surveyors who knew the ground, the surveyors general who answered to their states, the physical monuments that families could walk out and verify with their own eyes, replaced by calculations made in Washington, by engineers who answered to a commissioner, by a Secretary of the Interior already on record serving corporate interests. Your deed likely describes your property using language inherited from the Public Land Survey System. Section, township, range. If you own rural land west of the Appalachians, your legal description traces back to a survey. The question is which survey? The one a local man walked and marked in the 19th century, or the one a federal engineer recalculated after 1910 from an office in Washington, an office where the original field notes were filed, the contest records burned, and the fraudulent surveys never fully corrected? Every line on every rural deed in America is a claim about where the ground truth lies. Most people accept those lines without question. They assume the boundary was set generations ago and has never moved. But between 1909 and 1910, the federal government gave itself the legal machinery to move them. It passed 4 laws that dismantled the only system designed to prevent exactly that. It concentrated authority over American land boundaries in a department that was, at that very moment caught transferring public resources to private syndicates. And 16 years later, it burned the records. The lines on your deed are not carved in bedrock. They are drawn on paper, and paper answers to whoever holds the pen. Somewhere in the National Archives, the original field notes from your county's first survey still exist. Somewhere in a Bureau of Land Management office, the plats from the resurveys after 1910 are filed alongside them. If you placed them side by side, would the lines match? Has anyone ever checked? In most cases, the answer is no. Most rural landowners have never compared their current legal description to the original General Land Office survey. Most have never asked when their boundaries were last redrawn, by whom or under what authority. They trust the line because the line has always been there. But the line has not always been there. It was set. It was disputed. In many places, it was fabricated. And then the records of who challenged it were burned. The question that remains is simple. Who picked up the pen in 1910? And whose land did they redraw when no one was looking?